Salman, we're live?
Yes.
Thank you. Good afternoon, one and all. 2023 has been a whirlwind of legal developments, landmark cases, and shifting landscapes. Welcome, everyone, to this special edition of BW Legal World Salary Solutions to take a look at the new Criminal Procedure Code, which received the presidential assent on December 25th, 2023, called the Bharatiya Nagrik Suraksha Sanhita. Along with this, the Indian Penal Code and the Evidence Act have also been replaced, but the three laws are reported to come into force in some months. Today, we are focusing on BNSS with our esteemed panel of practitioners. Please join me in welcoming Senior Advocate Mr. Pramod Kumar Dubey, Mr. Parvez Memon, Senior Partner, MZM Legal, Ms. Neha Nagpal, Founder, NM Law Chamber. She's going to join us in some time. Mr. Alipak Banerjee, Head, International Dispute Resolution Practice, New Delhi, Nishit Desai Associates. Mr. Aviral Sahai, Partner, Dispute Resolution, Cyril Amarchand Mangadas. Thank you all for joining us today. Let's dive right into the discussion panels. Allow me to start with saying what my sense of the new procedure or the BNSS is. We see a lot of emphasis on reformation and rehabilitation, forensic evidence collection, tight timeframes for supply of reports and documents, use of technology in recording evidence, and in many ways has also tried to be more victim-centric. Would that be a correct impression, and how do your views differ? We'll start with Mr. Pramod Kumar Dubey. Sir, your thoughts on this first.
Thank you, Garima. And
Ashima, sir.
Sorry, Ashima, I'm so sorry. Thank you.
No worries.
And the BW legal team and all the panelists, and Happy New Year to everyone. We are going to enter into this new era of all the three laws enacted by the Parliament. One was termed as basically two were termed as the colonial law, though one CRPC was in the 1970s. So, in any case, the law has come, and we have got the opportunity to go through this enactment, especially Bharatiya Nagrik Suraksha. So, as per my opinion, this enactment is centered to four aspects. The first is the victim-centric.
Mm-hmm.
The second is the user of the electronic record and the artificial intelligence. The third is to expedite the proceedings, trial, everything. And the fourth is affecting the personal liberty. So personal liberty, whether it will be pro-personal liberty or against the personal liberty, will come subsequently. But first is the victim-centric.
Right.
So what they have done, they have given so many rights to the victim.
Mm-hmm.
Earlier, the jurisprudence was altogether different. The basic concept of the jurisprudence was that the violation of the fundamental right of the individuals. And if there is a right, there is a corresponding duty. And the corresponding duty was lying in the state. So if somebody has committed some offense, criminal offense, so they have violated the state norms.
Right.
So it is the duty of the state to protect the right of the accused. So on that scenario, the victim was not having the locus standi, and the offense used to be treated as the state offense, the offense committed against the state violation of the rule of law.
Yeah.
Now they have entered, and there were so many judgments earlier in time which says, victim does not have any right to interfere in the proceeding because this is between the state and the accused.
Right.
Now they have widened up the scope and given the right to the victim in so many circumstances, like suppose there is a registration of the FIR. Let us take example of registration of the FIR. Earlier it used to be 154. Now, as per the new law, it is 173. So it was 154 CRPC. Now 173D and then S. So they have given the two things. First, they have brought the in wider aspect the concept of the zero FIR. Though there was a zero FIR earlier juries also,
Right.
but now they have said it is the zero FIR. So zero FIR has the pro and cons both.
Mhm.
Earlier in time, the police were very reluctant to registering the FIR if they were not having the jurisdiction.
Right.
So far as the 156.3, which was in existence in the earlier in time. So there was some jurisprudence like they started with the trisome chemicals where the Supreme Court says, Subinder Singh judgment says, and various judgment of Delhi High Court and the Bombay High Court, other high courts also, he says the judicial aspect will not come to be in the question at the time of the registration of the FIR, especially under 156.3. And there is a concept of the zero FIR. If during the course of the investigation, the police comes to the conclusion the particular police station is not having the jurisdiction, they will transfer the matter to the appropriate police station having the jurisdiction.
Right.
And the concept was the judicial aspect should be considered, but
Mhm.
not. Nevertheless, there were also the provision on 156 to 156 to CRPC. If the investigation is being done and was done by any officer who was not competent, you cannot vitiate the investigation. So investigation would remain there.
Mhm.
So the concept of the zero FIR was already in existence, but now they have given a different color. The pro is that if the offense is committed one place, the victim can approach the police station of the other jurisdiction for
Mhm.
the remedy, and they can file the application, their complaint for the registration of the FIR.
Right, sir. So we
But
have your first thoughts, sir. Allow me to take one quick round across the panel and take this point further to Mr. Memon. Mr. Memon, like Pramod ji mentioned, and how our first impression of the code is that it is victim centric. What are your thoughts in taking the discussion forward from what Pramod ji said?
Well, Ashima, I completely agree with Mr. Dubey. With all due respect, he has been our senior and mentor all along. So we cannot differ with what he is saying because it is absolutely correct in my view as well that this is more victim centric. However, I have some bits to share to the extent that though the intent of the government to bring in this new legislation may be good, but you also have to be conscious of the fact that despite the ends being good, whether the means are equally good.
Right.
How are we going to tackle the difference that you have brought in with effect to bring a complete new law, all three new laws, be it the IPC or the evidence or the CRPC? Was there a need of complete overhaul in all three acts, enactments, or could it have been done with bringing in the amendments that was the need of the hour? The complete overhaul, in my view, though the intent is good, is going to create a lot of chaos in its implementation to the extent to know whether we are all ready to implement it at the word go.
Right.
The first thing is that all the three laws have to be studied by each one of us, including myself. We go back to the student age. I have to read all three books and mug up all the sections. For the last 25 years, we have mugged up IPC, CRPC, and Evidence Act. We have to now undo all of this and redo new sections and learn it. Having said so, apart from lawyers' problems, there would be problem also with the implementation right from the start where the investigation starts. Even if it
Right.
is victim centric, do we expect the Hawaldar ranking person to now understand the IPC in whole and also understand the BNS or BNSS or the other acts that have been brought into force? So
Yeah.
even if it is victim centric, there have to be teething problems for the implementation as such. I believe, in my personal opinion, it is something like, a hasty decision to bring in all the overalls. It could have been done in bits and pieces by amending the laws or bringing one act after the other or first having the training sessions. The judiciary will be required to be trained completely. Now, there is a lot of confusion in the minds of lawyers as to whether these acts have retrospective effects or prospective effects. Now, if the judge is vested with thousands of matters as on today, he will have to sit with both the sets of laws on one set, the 1,000 cases that are on my board today, I have to examine them with the lens of CRPC. The cases that are going to come to me from tomorrow onwards, I have to go to the book of BNSS and see whether the procedure is followed or not. So that chaos needs to be addressed first. Though this is victim-centric, somewhere it will be lost in the bargain of implementation is my view.
Thank you, Mr. Mevan. That's a great thing that you mentioned, that implementation and intent. I mean, intent is well placed, but how far implementation goes will hold the key to success of the law. Alipa, coming to you, what has been your key takeaway from the overhaul, and what are your first thoughts?
So I agree with Mr. Dubey and Mr. Meman. I think implementation will be a significant challenge, and even the Home Minister has clarified that uh, possibly they are looking at uh, a gradual implementation in the course of 2024. Overall, I think I would say that the from an intent perspective, this is good, particularly from two standpoints. One, use of technology, service of summons, taking evidence, and various other things, recording of audio-visual means when there's a search and seizure by police, and various other mechanisms. We can go one at a time.
Yeah.
Overall, the focus on technology is really commendable. Number two, speed and timeline. Starting from strict timelines when the judgments are to be passed within 30 days from conclusion of arguments can be extended to 45 days. Adjournments cannot be given more than twice. The lawyer is occupied with some other court, can't be a reason for taking adjournments. And similar other steps will significantly step up the criminal trial process. But whether our judiciary is sort of, they have the infrastructure to sort of ensure that that speed is implemented is a larger question. And another last point which I'll add, few interesting concepts have been introduced, like attachment of property. In ED cases under PMLA, under FEMA, we used to see attachment of properties, but even under the new code, under 107, property can be attached after an approval of the court. Then trial in absentia. This again will be a debate at a lot, where a proclaimed offender it has no intention of coming before the Indian courts. His right to be tried can be waived and the matter can be proceeded. Of course, there are certain safeguards when this provision can be implemented, but this again is aimed at sort of speeding up the trial process. So that
Right.
would be my preliminary thoughts.
Thank you so much, Alipak. New concepts introduced, we'll come to that certainly. Aviril, your first impression of the code, and how do you agree with the panelists, or do you have a varying view?
No, thanks, Ashma. I completely agree. And my learned seniors on the panel have already covered exactly what the mindset of the legal community right now is. Yes, some of us are of the view, was this really necessary after having analyzed the provisions? Was it necessary to go into an overhaul as such? Probably not, but then now we are stuck with it and we have to proceed and move forward on this. Over and above what everyone's covered, I think one aspect that that caught my eye and I have much interest in is the modification on the provisions for anticipatory bail. I'm happy to see that many vestiges that were there in the previous provisions of keeping the accused in court when anticipatory bail final hearing is happening, of an automatic ability to arrest without a warrant if the ABA is rejected. Those aspects have been removed, which is a good move forward, I believe. It follows a lot of precedents that have been passed by our high courts and the Supreme Court. So it's good that at least those aspects have been incorporated into the statute. Maybe a few misses as well. Some things like Miranda rights, providing written grounds of arrest, those aspects could have been covered, especially when they've now been read into other statutes by the Supreme Court. Yet again, it's something, it's a moving aspect, and hopefully we can reach those points as well.
Right, Avril. Thank you so much. I'll go back to Mr. Meman again. Mr. Meman, you've spoken, of course, about the implementation now. How do you suggest the businesses or stakeholders involved should prepare as we all await the notification?
So I optimistically begin on the note that it is good for the lawyers that now all the business houses would need us. So the first thing that they should do is approach us if they are confused in their heads as to the implementation. So it will be good business. That's a good news for lawyers. Number two is, of course, it's not a rocket science to have a comparative study on the previous code and the current code. There are books available in the market. Everybody will have to only update their libraries to see that what the law earlier was as against what it is now. There are not many changes in my personal view. You can only refer to the section previous and the current section to note down what is the difference between the previous law and the current law. There are hardly anything that I see except of the new things that have been introduced to the new BNSs, which we have to factor in. So it's not going to be very difficult. Of course, as I repeat, the implementation would be a bit of challenge for initial few years, not in long term. So that applies to any change. You know, if you want to bring change to the society, there has to be initial teething troubles, which we have to appreciate and adopt the law in its entirety and live with it. We have had experience of demonetization earlier. We have seen that the intent of the government was good, but there were initial hiccups. Now we are all used to using the red notes in the market. So that happens. Having said so, I believe there is not a bit of a challenge for the business world to understand what are the differences. Yes, they have to be cautious of their rights. They have to be also cautious of what is coming forth from these new laws, to the extent that, you know, technologically, as Alipak has rightly said, that this is an advanced CRPC technologically abreast. The warrants or summons can be served through WhatsApp. They cannot run away because earlier, you know, the corporate houses used to deal in such a way that, you know, the directors are not served the summons, the service is to be effectuated, the service report is to be filed into the court. If he is somewhere abroad, it cannot be, you know, prosecuted, and it could linger for long. So the intent of the government indeed is good, that to expedite the process of trial, this technological use is brought into force, where even trials can be conducted online through VCs, where the summons could be served through technological use, where evidence can be recorded technologically, FIRs can be lodged online. So all of this is good part. Having said so, the infrastructure is lacking. We are talking of metros. You are sitting in Delhi, I am sitting in Bombay. We can of course cope up with this. But do you believe that in a town like Chhattisgarh, Jharkhand, wherever the people don't even know what technology is or how this would work or function? The courts are not equipped with all of this. So we have to factor in everything as to where the problem arises. But yes, there is nothing to worry as such. It's not a serious cause of concern. It can be all addressed, of course, I repeat, through able assistance of lawyers like us.
Absolutely, Mr. Evan, I hear you. Abir, bringing you in on the point of summons being served electronically. I believe, you have some point to make on that. On what are your, say, suggestions to corporates dealing with that?
So fundamentally, Ashma, the service of summons, at least like Sir also pointed out earlier, there was an ability to say that I haven't received the summons, proper process has not been followed. But now, with electronic delivery of summons and service of summons, it becomes that much more difficult to combat that position. Also, earlier, this was just a technical difference, but earlier a summons on a corporate could have been done on any officer as such, and now directors have been specifically identified as persons eligible to receive summons on behalf of a company. And we all know that most investigative authorities immediately proceed against directors. So I think protocols have become important now in the minds of corporate India. Earlier, I'm not sure whether many companies were implementing, say, a practice code of sorts that the moment they receive a summons, what to do. Like immediately now, once you receive a summons, you have to get in touch with a lawyer, because that ability to dilate the issue may be slightly stunted. This is, however, aided by a few other aspects, which I'm sure we'll cover in detail later. But for instance, an ability of a police officer to summon someone above 60 years of age, their jurisdiction. Now, we know much, I don't mean to stereotype this, but much of the leadership in corporate India perhaps can use that provision to protect themselves against a a summons which has been received and from a jurisdiction that they are not in. So
Right.
I think preparedness, much more a higher degree of preparedness is required now, and a more conscious to it.
Right. You mentioned age, but is being infirm and a woman also part of that exception?
Absolutely, absolutely. Those are part of the exception, but those were there before as well. I think this aspect of protecting senior citizens within the country, it's a very welcome provision in my view.
Right, Aviral. Let me go back to Pramodji on this. Pramodji, you have extensively worked in this, and not just high scale matters, but also general blue collar crime. What is your sense of how this impacts the society at large? Let's take that at first, and then we come to the corporate world.
See, Ashima, basically, the moment you are mentioning that is a victim-centric, so the victims are also the part of the society.
Right.
But you cannot ignore the accused also. They are also the part of the society. And it is the duty of the state to protect the right of the accused. It is the duty of the prosecutor to protect the right of the accused. You cannot isolate the accused because, as per the jurisprudence which is in existence, the presumption of innocence in the favor of the accused until he is found guilty by the court.
Right.
2-3 things these are troubling us. Like earlier, there was a concept of the early and the speedy completion of the investigation. So there was a check that you have to complete the investigation in 24 hours. If you are not able, then the 15 days, then the 60 days or 90 days, and you can have the maximum period of the custody with the agency, enforcement agency, for 15 days. Now, so if there is a concept of the 15 days, so after the 15 days, the accused was able to move the application for the bail. Now they have extended the period would be 15 days, but subject to the nature of the offense, it could be 15 days within first 40 days or first 90 days.
Okay.
So suppose in first 15 days, they have not sought any police custody.
Right.
Then the accused moved the application for the bail. They come with the application, we are at the crucial stage, we are doing the investigation, we need the police custody. So in essence, you are depriving the accused from the bail for first 40 days or 90 days. Because the investigating agency has the power. They can come anytime, they can seek police custody. So what is the concept of the bail? So this is contradictory to each other. One side there is Article 21, another side there is a barrier by way of this 40 days and 90 days. This is one aspect. The second aspect, the beauty, earlier there was a 436A. 436A CRPC was saying that if you have completed the half of the sentence, then you are entitled for the bail. Vijay Madan Lal Chaudhary, it came in paragraph 4153 to 420 that the 436 is at par with the 167, that's the statutory bail. So now half of the sentence is there, but they have given the benefit to the first offender. If the first offender has completed 1/3 of the sentence, maximum sentence inside the jail, so he would be entitled for the release on the bail on the furnishing the bond. So this is the good thing, but the bad thing is 167. Another thing is a very important aspect I would like to highlight. That is, earlier there was a provision of taking issuance of the summons under section 200 complaint case. So the 200 complaint case, you have to get the evidence recorded, pre-summoning evidence. That is called in parlance, the legal parlance, the pre-summoning evidence. So pre-summoning evidence cannot be recorded without the taking the cognizance. Once the matter is put, recording of the pre-summoning evidence, so there is a deemed cognizance. There are so many judgments of the Supreme Court. So you have already taken the cognizance. So that portion you have already taken. In the new law, that is the 223 BNNS. But then you record the pre-summoning evidence. After the pre-summoning evidence, you have to hear the victim. So the victim, proposed accused.
Okay.
So proposed accused would come, he will disclose his defense. After evaluating the defense of the proposed accused and the complainant case, then you will take the cognizance. And without taking the cognizance, you cannot summon. But you are summoning the proposed accused before taking the cognizance. Though you have already taken the cognizance for the pre-summoning evidence. So there's a lot of contradictions. So I don't think this is going to be smooth. There would be a lot of judicial review on these provisions. So these are the things. The expeditious trial, the other panelists have already mentioned, they have put the expeditious trial, but it is not possible in India in present scenario because we don't have such infrastructure.
Mhm.
You have the intention, you can enact any kind of the law for the betterment of the society, but you need a strong enforcement agency with all kind of the infrastructure.
Right.
These enactments, they are basically the electronic evidence. Electronics means recording of evidence by way of the videography, sending through the mobile. So you have to get cyber law strong. You have to make the cyber law related laws more stringent.
Right.
You need the good quality of the forensic science laboratory to rule out any kind of the tampering.
Mhm.
Because as on date is very easy. There you will find in the gray market. I don't know about the Bombay, but in Delhi you go to gray market. We are talking. Your mobile is not being used, but I'll receive the message on my mobile saying that Ashima has sent this particular message to me. You have not used.
Mm.
So this kind of the software are in existence. How can you rely on the summoning of this process by way of the mobile? You can't. You need that kind of the check and balance.
Mm.
Then you can go in the development of the society.
Right.
So my stake would be the enactment has already passed, got the assent of the President of India, but the government should do all this basic homework before bringing this act in the existence.
Right.
And government should also re-examine if there are the contradiction with Article 21 and the other existing provisions of the Constitution. They should give the look. They should remove all this ambiguity for the smooth functioning of the system.
Right, sir. Very well put, Pramodji. Now, given this situation, my another additional question to you is, uh, अब यही है जो है तो अब what is the
No, there is no doubt. There is no doubt. See, we have to adopt. Suppose the new law passed from the parliament as per the demand of the society, we have to. There is no, and you'll find there is a change in the number of the sections, like 200 to 223. That will create the problem. Is they should have not done, but we don't know what came in the mind of the legislatures and the committee was constituted for this understanding committee. We don't know what there was no harm by adopting 173 as a 173, 154, because you'll find most of the sections, the language are the same.
They moved around.
Everything is same. There are some additions. So you could have done even by way of the amendment of the CRPC.
Right.
There was no need to completely change because you are changing the entire system. The precedent would be changed, the software would be changed, the previous judgment would be changed, the library would be changed. So everything would be changed. That would create the problem, but that is the transitional phase. Now we don't have any option. We have to accept.
Right. On a lighter note, a lot of classic Hindi movies will have to do away with 400 BC. So, Mr. Memin, bringing you in, we've heard Pramodji on the friction in the provisions and the procedure when it is on field. What are your thoughts and what's the recourse that you can suggest here?
Yeah, Ashima, I was just raising my hand to make more on the point that Mr. Dubey was raising about use of technology. I believe the legislators have forgotten to factor in the fact that technology can be used as well as abused. We are currently dealing with the deep fakes that the
Yeah.
Prime Minister was so concerned with, that we have seen the deep fake news about everybody, including himself, the
Right.
Honorable Prime Minister. So this technological advancement, though it comes handy, like they have allowed the Havaldars to even use their mobile phones for videography. It's not necessary that they need to carry a videographer or a camera along to videograph. They can do
Yeah.
it with their mobile. But as Mr. Dubey was pointing out, that today we are living in an age when we are just standing together. I can receive a message from you despite you not sending it to me. How do we meet with such situation? How do we meet with AI manifestation to the extent that evidence can be created, manufactured, doctored, tampered, whatever it is?
Right.
Tomorrow, if it is admissible in law that investigating officer, be it the rank of Havaldar or a police officer, API, ASI, whoever it be, supposingly tomorrow he is recording a recovery panchnama, which is now mandatory to be recorded. He starts the video, then he pauses, then he tells me to do something, then I do something, then he again starts recording, then he again produces it before the court and it is admissible.
Right.
So how does the accused then defend himself? Can the AI, we are living in the age of AI. Now AI can, modulate my voice. AI can modulate what I am speaking. Maybe on this webinar, I am not the real me. It is my
We
avatar.
hope you are.
Yeah, so all of this had to be fact when you are dealing with technology and bringing it in laws for
Right.
implementation in judiciary. You have to factor everything. You can't just say that this looks very promising, so let us bring in, and tomorrow we don't answer the challenges that are in the face of it.
Right.
So all of it need to be factored in. As I again repeat and again add to what Mr. Dubey has said, that there was no need of complete overhaul. We could have done with amendments, but it is what it is. We have to live with it.
Right. Right, Mr. Memon. Pramodji, coming back to you on that.
Ashma, I would like to flag one aspect.
Yeah.
It was just pointed out by Mr. Menon, the misuse of this artificial intelligence and the electronic.
Right.
One thing is very important. You have to maintain the balance between the right to privacy and your investigation. What measures you have taken to ensure that the whatever is going within the four corners of the wall will not go in the public domain?
Right.
Not necessary. The right to privacy, you have to see the mandate of the Supreme Court, Puttu Swami, and so many judgments.
And also the courts have held that you cannot force somebody to give their passwords to devices.
So many things. So there are a lot of judgments are in existence. So there will be a lot of problem. That would be this act is not going to be smooth without the judicial scrutiny. Every day we will come in. We don't know what kind of the future is we are going to meet, because we have to see we are practicing in this criminal law. We have to follow the law passed by the land. We have to do respect, because the temple of the society, this parliament has the past, our
Right.
first signal president has given the essence, so we have to follow. But there would be a lot of problem in this amendment. But you have to balance everything. You cannot implement the law, all these three law in the one law, that's a BNNS, in isolation. The
Yes.
government is the paramount duty of the government to get the stronger and stronger other law, also the constitutional law, because the entire criminal proceeding is based on the constitutional provisions,
Right.
especially Article 21. And every right of the citizens most of the right fall under Article 21. Because it's a jewel of the Constitution, Article 21.
Right.
So
Absolutely.
you have to keep the Article 21 in mind. Then you correlate all the provisions. Then it would survive, and then there would be effect in the society. So there are so many problems.
Right, sir. Very well said, sir. Aviral, bringing you in, your comment.
Just one minor comment on that. I think Mr. Dubin raises a very important aspect of the interplay between privacy, personal liberty, the current provisions, because one of the provisions that have been brought in is an ability of a magistrate to compel an accused to give their data signature sample to avoid bail, to avoid rejection of bail. Now, effectively, what the law is saying, we're incentivizing you to willingly give up your biometric data and your signature sample, and we will incentivize it by granting you bail. Which bail should be a matter of adjudication separately based on the merits of as against the willingness of a person to give up their personal liberty rights. So that one provision is something that I also have a personal concern over. But that's just one point I wanted to make.
No, very well said, Aviral. In fact, taking the discussion forward, there's also change in anticipatory bail provisions. Would you expound on that as well?
I think on anticipatory bail, like I said at the outset, I think that's one of the areas where good progress has been made. Earlier, the provision on anticipatory bail had at least contours of what the court has to consider to grant anticipatory bail. Those have been removed, though I don't think that will be a major change in how our courts approach it. Precedentially, they look at the same aspects of severity of the offense, past antecedents of the accused, but where it progressed, in my view, is earlier there was a mindset under 438 that if a person is applying for anticipatory bail, there's something wrong, and that person assumed that they have done something wrong and they're coming for protective relief. And this was very evident in the section, because it said that if interim relief is rejected, then the police can arrest without a warrant. It said that if interim relief is granted, the public prosecutor given immediate notice and will then have an ability to come and oppose the application and dispose it off on the next day. It also said that on final hearing, the accused has to remain personally present, which meant that the accused can be arrested should the ABA be rejected. Now, all these three provisos have been removed, thankfully, and it does allow for an accused person to ensure that their their liberties are protected, and even if an ABA is rejected at a sessions level, they can go to a high court without the fear of being arrested from a rejection.
Right. Alipak, I'll bring you in one moment. Aviral, once again, forgive my ignorance, but will preliminary inquiry and anticipatory bail work in tandem now that there's a provision that the judge can ask the accused to come in? Can that have any impact on the bail?
Probably, because even though this is not this was not there earlier under the CRPC, there was an unwritten mandate within investigating authorities. I do know for a fact that it's there with the economic offences wing of both Delhi, Bombay, and other cities, where for offences which were punishable up to 7 years, there was a mandatory preliminary inquiry stage. Now they've brought it in within the provisions of the statute itself. And that, I believe, will help the judges as well, where they can ask for the update on the preliminary inquiry and thereafter take a view on the severity of a case and the possibility of an accused of fleeing the country. Yes, most definitely it will help during an adjudication of anticipatory bail proceedings. That's pretty much it.
Right. Thank you, Aviral. I'll come back to you again. Alipak, bringing you in for your comment on this.
Yeah, so one point, like as Aviral rightly mentioned, because of the fear of being arrested, if the anticipatory bail application was rejected, what many lawyers would advise their client would be typically to file a criminal writ and ask for a no coercive order. Well, Supreme Court has last year said that you can't pass blanket orders, but in some high courts, we still could prevail. I think now that there is more clarity on anticipatory bail, and I think now more and more people will be inclined to actually move a bail application rather than clogging the high courts in a criminal writ and trying to get a broader no coercive order, which in itself was a little bit of challenge sometimes.
Right, Alipak. And continuing that conversation, can we hear from you what technology, and get into the specifics rather, of technological advancements that have come in and the timelines that have been set for various
Sure.
things?
So to start with, I think they've defined audio-visual electronic means, and they've defined electronic communications in the broadest possible manner. For example, audio-video electronic means have been defined to include video conferencing, recording, process like identification, search, seizure, as well as transmission of electronic communication in the broadest possible manner. Similarly, for electronic communications, they've defined it to include telephones, mobile phones, wireless telecommunication devices, cameras, video cameras, and also they've also created a residue where the government can also notify new means in that sense. Now, after the definition, the most important provision, in my view, would be Section 530 of BNSS, where they say that all trials, inquiries, and proceedings has to be commenced or has to be undertaken in a manner which is compatible with technology, electronic communications. Service of summons, I think Mr. Memon discussed. I'll not repeat. Warrants and summons can be serviced through electronic means. The FIR can be registered through electronic means, although it says that within 3 days it has to be signed.
So 1 second, Alipak, I know panelists, all of you have mentioned this, that something can be effected by, say, service on electronic devices. Now, what is somebody to do if their device was actually switched off? Have they not read? Something went into spam?
Well, there has to be a service in sense service report that the person has been serviced. I mean, ordinarily, if you WhatsApp, there's a double tick, but someone could disable the confirmation.
Yeah, I've disabled my ticks. So now how does somebody?
Possibly some kind of an affidavit needs to be filed that you have effectuated service, or with emails and read receipts. I mean, some kind of confirmation needs to be there. Otherwise, merely sending, you may not be using that mobile number. Forget about switching of the device.
Yeah.
You may have changed your mobile number. The law enforcement can have a mobile number which is dated. Then how do you serve that person, right?
Yeah.
So I think service reports will have to be filed, and over there, the prosecutor has to be explained that how service has been effectuated properly.
Right.
Now, in terms of recording of search and seizure, again, it has to be videographed. But like Parvez mentioned, a very good point that when typically such incidents happen, the proposed accused, they are purely at the mercy of the law enforcement officers.
Right.
Law enforcement can selectively record it.
Yeah.
Then what happens? And if that piece has to be used as an evidence in a court of law, then the accused may not have full ability to say that, well, selectively it has been recorded.
Can the
So-
accused record as well? Is there any such statement in the law?
I don't believe so. I think it just says that law enforcement can do it. They can use the mobile phone to record. I think the law stops at that. I don't believe that they've gone anything more than that.
Right.
The other point is for in terms of offences committed outside India. Earlier, the accused had to come to India to participate in the trial. Now they can do depositions online, so that is a good development. I think it will speed up. Then evidence can be recorded online. Sometimes the accused need not be produced in the court. Even from the jail, they can participate in video conferencing and participate in trial. So all these mechanisms have been prescribed. But of course, like everyone said on the panel, they have catered to the good use of technology, but I don't think they have factored in the bad actors and how it can be sort of misused.
Yeah.
Maybe some guidance on that will help. Now, in terms of timeline, to my mind, this I think is the biggest highlight of the new enactment, but there is a lot of judicial infrastructure that we need to implement the timelines. First one that I'll start with is, of course, we under 173 of the existing law, there's a timeline to file a police report, what we ordinarily call as charge sheet. But there was no timeline for filing additional charge sheet. Like after a charge sheet is filed, typically when people file for quash or something, or in many cases, what the law enforcement will say that, oh, we have only done a preliminary investigation and filed a charge sheet. We are undertaking further investigation, and so don't quash. We have more material to adduce. So today there is a timeline which have been introduced in the enactment under 193A of 90 days. It can be extended, but with prior permission of the court. Earlier, for additional investigation, no timeline was there. Number two, when an accused is produced before the court, I mean, in terms of giving the documents to the accused, earlier it took a lot of time. I think now 14 days have been provided where the magistrate has to effectively hand over the documents to the accused person so that the accused can take the next steps. In a criminal trial, this step earlier, I mean, not earlier, I mean, in the current situation, it can take a lot of time. Then 60 days have been prescribed to file a discharge application that will speed up. Framing of charges will have to be done within 60 days from the first day of hearing. So, in our experience, framing of charges, it took a lot of time. And because it was marred by delays. Now 60-day timeline has been suggested. Then, most importantly, judgments of acquittal or conviction will have to be passed within 30 days, extendable maximum up to 45 days. I think this is
Right.
also very good. I mean, a magistrate will hear multiple cases. So the question as to whether they can really write a good order in 30 to 45 days is a big question. But in terms of the intent, I think this is very good. Plea bargain, you need to file it within 30 days from framing of charges. Absence of complainant, I think this I adduced in an absence of complainant in this situation where in a non-cognizable offense and which can otherwise be compounded, if the complainant is not available in spite of due notice of 30 days, then the court can discharge the accused. So this will help in a case which is non-cognizable and where there's a frivolous prosecution. Then when the complainant doesn't show up before the court, people can get discharged.
Right,
So this
Alibag.
is
I'm conscious of the time here, so I'll possibly will need to get others in as well on this. But thank you so much for taking us through the different timelines. And Mr. Memon, bringing you in here on one very crucial aspect that we haven't touched so far is attachment of property. Uh, we know that it exists in the PMLA, and then of course the enactment says that in terms of any friction, the special law will prevail. Now, where do we stand in terms of that?
Well, in my view, it is a bit draconian in its current format to give those powers to be vested with the police authorities. In special statutes like PMLA or other such statutes we had in the past, like MCOC and all, which we call in terms draconian acts, there are provisions to protect misuse or abuse of such law, like a officer of a certain rank is authorized to investigate such kind of offenses, or there are preludes to provisions of attaching properties. Here it is left to the discretion of the police officer, and it's very easy to put anybody in trouble. So I foresee quite a lot of misuse of this provision of attachment of properties, be it of a director of a company, his personal properties, or individual offenders whose properties are at stake and at the mercy of the police officer without any checks and balances. So whenever there were earlier enactments which were special statutes like POTA, TADA, MOCA or PMLA, there are checks and balances in place. However, putting it omnibus in CRPC, giving powers to all and sundry, in my view, would create a lot of problems in implementation. It could be selective implementation. It could be vindictive implementation. It could be for the purposes of harassing somebody. So I foresee quite a lot of misuse of these provisions in the form that it is.
Right. And any recourse that comes to mind currently, given the
The
situation?
only recourse is courts. So you have to run to the courts. Of course, I being an optimist person, I foresee more business coming in. But the only recourse is run to the court, protect your property, protect your liberty. And it is left for the court's discretion. As Mr. Dubey again rightly said, that we will see so many litigations in this regard about implementation, bad implementation, interpretation, confusion. So every day there would be petitions coming in high courts and Supreme Courts, and of course we will be part of it. So that's it from my side.
Thank you, Mr. Memon. Taking a leaf out of your optimism, we'll have many more discussions like this time and again. So it's good discussion time as well for us. Pramodji, coming back to you, sir. We've gone around the panel and taken everyone's view. We'd love your sort of conclusion on where we stand, something that our different stakeholders can take from this, even students for that matter. Now, everyone who has been given this new enactment to read, how would you tell them to go about it?
See, the reading the enactment is not the problem. The only problem is the implementation. Like in the earlier question you have put to Mr. Menon, and he explained so far as the attachment is about. Even in the PMLA, there is a provision for the adjudication, there is a tribunal. Then, if the attachment is confirmed by the adjudicating authority, then it confirmed from the appellate tribunal. You have the remedy to go to the. Ultimately, it will be subject to the trial. Here, you are putting all the burden on the magistrate. The magistrate is having a lot of things to do. That's the Ilaka magistrate. Bail, miscellaneous applications, superdari applications, traffic challan, so many things. And you are also putting the timeline to pass the judgment. The judgment should be appreciation of the entire material and the existing jurisprudence, the law. Why the court requires time to pass the judgment? Because the court has to evaluate each and every aspect. See the interest of the society, individual, the facts, the law, the evidence, everything, then to write the judgment. So you are also putting the pressure on the court, do in the 30 days, you do in 45 days, but there is no check and balance of your police organization. You can do anything. You do anything, and ultimately it will go to one mistake. And the magistrate has to decide everything without providing the infrastructure. So far the timeline is concerned, I think the best way was to just pass the provision that the concerned High Court, inter se will, made the enactment how the particular case would be decided.
Right.
It depends upon the infrastructure of each and every individual High Court. Like I had the occasion to argue one matter in Andhra Pradesh High Court. So we moved the bail application. The court kept insisting, I have to decide the bail application. There is a mandate of the High Court to decide the bail application within 7 days or 14 days. I cannot adjourn at all because the bail is a personal liberty. And even the Satyendra Kumar, until judgment of the Supreme Court says you have decided in the 14 days or timeline. So I have to decide. But even if you come to the Delhi and other state or like the Allahabad, you won't find the bail application is being listed for the 6 month year. In the event the High Court 3 months, 4 months, in Bombay High Court, the listing is a big problem. So how the informed law would be there in Andhra Pradesh, in Delhi and Bombay and the Northeast state? So it should have been left to the domain of the particular High Court. High Court could frame give the direction to their officers. You decide this kind of the offenses and this kind of the matter in this timeline, this time. There is a monitoring by the High Court committee also, the administrative side. Right. There are so modalities. It could have been resolved. But informed law for the entire country, we have the remote state. If you go in the Uttarakhand, you will find the courts where the courts are situated. And how the difficult to the litigants to go from one place to another place and the witnesses. So the law is what? As per earlier section 309, now they have enacted 346. So maximum 2 adjournment by each party. Suppose the witnesses are not available. The lawyer is not available. There is a problem. The files are not there. Problem with the investigating agency. So many things. Or during the course of the cross-examination, we are coming across a new material. We have to summon that record also. Of course, the matter would be adjourned for the summoning of the record. So how it is possible you just give the number to? Yes, earlier was good. It should be day to day. No adjournment without reasonable cause.
Right.
But giving the number 2. It's not that the opportunity you are giving. It's the question of the personal liberty of the individual. Whether the accused or the right to the victim. Every person has the liberty. Every person has the right. So it's the right of the individual. Being the counsel for the defense side, we are not siding with the accused. No, sometimes we are also appearing for the complainant. Every time we are appearing for each other. So it's the right of the individual. You cannot give him the number And what is the reason for giving 2? It should have 3 also, 4 also, 5. Why the number game? Why the number game? The intent is expeditious trial.
Yeah.
So the enactment should be so strong, there is no adjournment unless and there is a reasonable ground.
Yeah.
So this kind of the laws would have. So basically, what we are coming across in this law, there is a number game, there is a implication of the technology, the limitation of the date. It is not required. Even you give the discretion to the judge, we are going to decide this matter. There is a timeline of 30 days. How many witnesses? 5 witnesses. These are the date waited in advance, no adjournment. You come with the witnesses, cross-examine, matter closed. So rather giving the timeline, it was better to give the timeline at the inception. If charge sheet is filed, the documents have already been supplied, charges have been framed. Now the trial starts. Trial will be completed in such and such period. The prosecution is directed to ensure the presence of witnesses, all the material. Defense is also, and give the date as per the defense diary and the convenience of the witness also.
Right.
It will solve the problem. Even
So
in
coming to your point on examination, sir.
If you go to the foreign country, other country, like in the arbitration, everywhere there is a. So it's basically who is going to implement all this? That's a magistrate, that is a session judge.
Right.
And every day we are crying the pendency, but we are in what we are doing? We are increasing the pendency, not reducing by complicating all this thing.
Complicated is the word. Pramodji, again, we were discussing this offline on examination. Now, apparently the court can also complete the examination in the absence of the lawyer. What do you have to say about that?
I don't agree with this provision. Because then what is the trial then? What is the meaning of the trial? The meaning of the trial, that one person is putting a fact. So he would be put on trial. Trial by whom? Obviously by the opposite party. Then the opposite party will see whether the person has basically carrying the good character or not. Because the evidence is you have to impeach the conduct also, character also, trustworthiness, relevancy, admissibility. So everything would be tested by the cross-examination. If the opposite party is not there, where is the question of the trial in absentia? So earlier there was a provision under 299 just to segregate the proceeding. And after the segregation of the proceeding, the accused who are remain, they were present before the court. The trial will commence, trial will come to the logical conclusion. Whenever that accused will be found who is already declared, proclaimed not available before the court, then his file will be open. He will also be given the opportunity to try the person, and then the court will come to the conclusion. Today, if you are doing the trial in absentia, tomorrow the person would come, he would say my personal liberty, right to fair trial has been violated. Again, it will start from the zero. From the start, from the inception itself. So what is the purpose? What you are going to gain? And even the trial is in absentia, the person is not available. Where you are going to execute the punishment or the outcome of the trial? Where? If the person is not available, trial is in absentia. The ultimate game, what is the entire criminal jurisprudence? The state has to ensure that there is a rule of law.
Yeah.
To maintain the public order. The message should go to the society that if you are violating this provision and violating the rule of law, violating the public.
Pramodji, I think we've lost your connection. We'll wait for Pramodji to join us. Mr. Memon, coming to you. Pramodji was making a point on
Asima?
We can hear you, sir. I think Ashma's
So there is a electric problem, but again and again there is a problem coming in the office.
I think Ashima's facing the same issue.
I think so. She's must be around, no? In the nearby, the same zone. So very unusual. Again and again there is a connection problem.
Sir, this is what we will experience in technological conduct of trials also.
But sir,
Again, Mr. Dubey, I think we have lost him.
this is
It's not a,
very people this kind of
not a good audition for use of technology in trials at all.
Imagine I am putting a question to a witness online,
Right.
and in Chhattisgarh the light goes off. What do you do?
They'll prepare for the question.
Yeah. And as Alipak was saying, that then the magistrate would continue the cross in my absence.
Right. Of the electricity every time some tough question is.
No. Then we'll need to do what we do in arbitration, right? Have different cameras.
even you will torture the accused or the witness.
Yeah.
Now the witness will come and say whatever you want to say on the video, and that is admissible piece of evidence. That thinks he's still in problem.
Is there anyone else from BW Legal on?
I think she is in defense only. She is joining back. She is joining back. A lot of problems. Pravesh, when are you coming?
Sir, January में है 2-3 listed. We will see you soon.
See me soon or see some other person, then I would be in transit.
No, sir, I will come specially to see you.
But I'm also planning to come over there, Bombay.
Please visit our new office, sir.
Your office is our office, also.
Yeah, it's
Especially my office.
Please come, sir. आपका चेम्बर खाली रखा है हमने.
Yeah, now she has joined, Asima.
Thank you, panelists, for holding the fort in my absence. And this is a fine example of how vagaries of technology can hit us at bad time. So, Pramodji, I'm sorry I wasn't there, but maybe I can come back to you on the point that you were making.
Yes, so I was just making all these points. the and what we have come across the committee report, uh, you hardly find that's the person who are practicing in the criminal side were the part of the committee, because they are the best person who are facing the day-to-day problem in the court. And there must be the retired judges also. They have the trial experience, so they should have given their input. But in any case, now the law is law of the land. We have to respect our law, and
Right.
we always say this is a good law. There is no doubt it is a good law. Intention is good, implementation
Yeah.
is good. So the government should focus to fill all the lacunas, make it all stronger, and gain the confidence of the society. This is my
Right. Thank you. Thank you so
conclusion.
much, Pramodji, for
Thank you.
enlightening us on so many aspects of law and jurisprudence in the wake of the new enactment. Mr. Memon, coming back to you for your additional thoughts on this as we wrap this discussion.
Yes, Ashima, so taking cue from what Mr. Dubey was saying, I believe that the legislators in their wisdom have given more emphasis to the court, justice delayed is justice denied. However, at the same time, they have forgotten the court, justice hurried is justice buried. So you have to take care of the rights of the accused, as Mr. Dubey was emphasizing on. The principles of presumption of innocence, I think, somewhere stand diluted with the way the current structure of BNSS is. And we will face a lot of challenges in courts. Maybe the courts would come to the rescue of the petitioners when they approach by ruling certain provisions as ultra vires as against Article 21 of the Constitution. And we will see how it shapes up. But nevertheless, the intent is good. We have to accept it with open wide arms, and we will all adopt to the new laws. And we expect good things to come up in the years to come.
Right. Thank you so much, Mr. Memon. Aviral, coming to you on that, and any additional point that you would like to make on what we discussed today?
No, not much. I think both Mr. Dubey and Mr. Memon have covered the general thought process that we as lawyers have. I'm also slightly hopeful to see the accountability that police officers may now have slightly increased. Maybe lesser abuse of powers on video. Maybe lesser delays in investigations because they have to keep a victim or an informant informed and
Right.
keep submitting case diaries. So let's see if that practically does work out.
There's also a directorate of prosecution that has come into existence.
Exactly. That's also perhaps a judicial, not a judicial, but a legal mind being applied to the actions of the executive, which is also a good move forward. So I'm hopeful to see how things proceed.
Right. Thank you so much, Avril. Alipaq, your thoughts?
No, I think implementation will see the timeline when that is made public. But what I see is a lot of judgments by high courts and Supreme Courts to plug the gaps or to sort of interpret some of the provisions. Like we have seen in IBC, like Justice Nariman was the benchmark. He sort of single-handedly from Supreme Court, he guided so many. Similarly, we'll have judges across the country who will sort of give more guidance in some of the provisions which are not very clear or in some sense which violates the sort of principles enshrined in our constitution. So the judgments will sort of shape how sort of this needs to be looked at from a practitioner's perspective.
Thank you, Alipaq. And I guess in times to come, the jurisprudence would have started from this year onwards through all of you. So we look forward to some new judgments, new jurisprudence on the enactment. Thank you, experts, for joining us today. This has been a wonderful conversation, and I look forward to engaging with you offline to get your thoughts on more specific details. Thank you so much.
Thank you.
Thank you so much.
Thank you so much.
Pleasure.
Thank you.